Thank you both. All right, unless we have anything further from committee members, we're going to turn to the main topic of today's hearing, which is accomplice liability for murder and firearm enhancements. Okay, these are complicated topics that present important issues about public safety and equal treatment under the law. As we note for many issues, California has been a national leader in making its accomplice liabilities laws more fair and effective. As we've just heard, in 2019, the legislature passed its landmark bill, SB 1437, which was authored by Senator Skinner, which eliminated or updated the legal doctrine on felony murder, which had allowed people to be punished with a life sentence for murders they did not actually commit. But as we will hear today, important follow-ups to SB 1437 remain to be done because how the legal system has responded to the new law. We will also consider the similar legal rules around so-called provocative act murders and the laws around certain firearm enhancements, which do not appear to be rational ways of assigning punishment, and that in some instances present disturbing examples of racial disparities in our system. So let's get into it with that introduction. Let me say a few words about how we're going to be doing today's hearing. First of all, as always, we have a terrific memo from staff, and we're going to be leaning on staff more than typical today to walk through these issues because they are so dense and complicated. We're going to be taking a new approach by having staff begin the discussion with a presentation that will bring us up to speed on the relevant law, data, and recent developments. We'll also have two expert witnesses who will give their own brief presentations to supplement the staff presentation. Committee members, please feel free to ask questions during any of these presentations, but we'll have Q&A as always at the end once the presentations are done. Keeping in mind our calendar and what we're trying to get done with regard to our final recommendations, my goal for our discussion today is to arrive at a consensus on recommendations on these issues for this year's report. So unlike our other issues, we have a little bit less time to talk about them. Before we begin the presentations, I want to thank each of our panelists for sharing their insights with the committee and preparing written submissions for us. Our panelists today are Jennifer Hansen. I don't see her yet.
Sure.
Oh, there you are. Hi, Jennifer. From the California Appellate Project, and Nathaniel Miller, who's attorney law. Hi, Nathaniel. But first, I'm going to turn it over to Tom and Rick.
Great. Okay, everybody buckle up. We're going to go through some pretty dense material, and we have done our best to try to make it accessible and legible. But it is dense, and as Mike said, please ask questions, and we'll get through it together, I hope. Okay, so let's get started. Just a quick overview of what we're going to talk about, which, as Mike said, is punishment for accomplices, people who didn't directly commit an offense but were involved in it, and we're going to particularly focus on how that works for murder offenses and firearm enhancements at the end. About 80% of our presentation is going to be about what's happened after SB 1437 with accomplice liability for murder that affects the most people, as we'll hear about, and then probably about 15% will be about this provocative act murder issue, which is different but related. And then the last little bit will be about the firearm enhancements, which are much more straightforward and also affect the fewest amount of people, probably a few dozen every year, if that, on the firearm enhancements. So
the overall umbrella is that these are murders and murder convictions for people who did not actually do the act of killing someone.
Exactly. Didn't do the act and didn't intend to kill anyone. It's that combination of things that I think makes this really relevant for the committee and very much in the SB 1437 world and worth looking at. So I just should have gone to that slide when I said it. So that's the sort of the theme, as Mike said. All right. So I want to cast our minds back to before 2019 when SB 1437 became law. There are essentially four leading theories where an accomplice, meaning person didn't actually wasn't the actual killer, could be convicted of murder. And these are the four theories, and we'll go through each of them, and we'll explain sort of the concepts of accomplice liability, what malice is, and those sort of percolate through the rest of the presentation. But these are the four theories we're going to cover. Again, this is no longer the law, it's what the law changed. I think it's important to see that dynamic as we sort of see what has happened in the courts after. All right, so the first is aiding and abetting express malice murder. So to understand this, we have to talk about what aiding and abetting is, what basic accomplice liability is. This comes from Penal Code Section 31, and the basic rule is that anyone concerned in the commission of a crime, whether you do it directly or you aid and abet, you can be punished for that crime as if you did it yourself. So there's no diminished punishment. You are as responsible as the person who did it. And courts have also added this element about what you have to intend to do. The accomplice has to have knowledge of what the direct perpetrator is going to do and also have the intent to assist them to do it. So you can't sort of accidentally be an accomplice. But that's the general idea for accomplice liability. And then we have to get to the express malice part of that first theory. And to talk about malice, we have to sort of situate that in the definition of murder, which is pretty straightforward. It's the unlawful killing of a human being or a fetus with malice aforethought. I think most of that makes sense. It's just really this question of what does malice mean? Malice is what makes a killing deserve a life sentence under California law. It's the thing that is sort of most blameworthy about the killing under the law. And that's what takes you from a manslaughter conviction, which has a determinate sentence, to a life sentence for murder, as if there's a killing with malice. Unfortunately, malice itself is quite complicated, and there are two ways it's defined in the penal code. There's express malice and implied malice. Express malice is pretty straightforward. It's a deliberate intention to unlawfully take away the life of a fellow creature, is how the penal code phrases it. And that is sort of, the most straightforward murder you could think of. Someone, picks up a gun, points it at someone's head, says, "I'm going to kill you," pulls the trigger and does so. That would be pretty clear express malice. There's also implied malice. And this is a concept that's going to come up a lot more later in the presentation, but I want to introduce it here. So the penal code says implied malice is when you have an abandoned and malignant heart. Courts has said no one knows what that means, and they've created their own three-part test for that we'll go through very briefly, because this is going to become really important later. Basically, for an implied malice killing, you have to do an act that has a high degree of probability it will result in death, so something extremely risky that is very likely to kill someone. The defendant has to know what they're doing is that dangerous, and they have to do the act anyway. They have to disregard that risk. So this is the prosecution actually has to sort of show what the person was thinking to show an implied malice murder. So that can be quite tricky, and as we'll see, not always required in some other murder convictions. So that takes us back to aiding and abetting express malice. So if you're an accomplice in express malice murder, you are intentionally helping someone who is very clearly trying to kill someone. So in the example I used before, if you were to hand a gun to someone and say, "Kill that person," and then the person who takes the gun and shoots the person in the head, that would be a pretty clear example of aiding and abetting express malice murder. Sort of the most straightforward, and I would say probably uncontroversial theory used to convict someone of murder. Now we get into the felony murder world. So there were two felony murder theories. The first created a first-degree felony murder conviction, which means the sentence would start at 25 to life. And the way it works is that the penal code has 14 felonies, and if there's a killing during one of those felonies that's listed in the penal code, you don't have to show malice anymore. You just have to show a killing happened during the felony, and that would, before SB 1437, get you to first-degree murder. And if you were an accomplice to the underlying felony, meaning you assisted in any way, even if you didn't intend to kill anyone, you could also be convicted of that first-degree felony murder. We also had a second-degree felony murder rule that was largely created by courts. So this was a killing that happened during a felony that wasn't one of the 14 ones listed in the penal code, but that was determined to be inherently dangerous. And if a killing happened during that, again, no requirement of showing malice of an intent to actually kill someone in any way at all. And that would get you second-degree murder. And again, if you were an accomplice to the underlying felony that was inherently dangerous, you could also be convicted of that murder. And that takes us to the fourth pre-SB 1437 theory, which was natural and probable consequences murder. So unfortunately, to understand this, we have to go back to our accomplice liability slide and add a third concept, which is that an accomplice was liable not just for the offense that they sort of knew that the perpetrator was doing and intended to help with, but you were also liable for any offenses that were a natural and probable consequence of what is called the target offense, the original offense. So the way that worked with murder was if you were an accomplice, say, to an assault offense that ended in murder, even though you didn't intend to kill anyone, you could also be convicted of murder under that theory, under the natural and probable consequences theory. So again, this was the pre-SB 1437 world. These were sort of the four leading theories that were used to convict accomplices. SB 1437, as we've heard many times already from Senator Skinner, of course, became effective in 2019. One of the reasons that the law was passed, as this was in the findings and declarations, the second bullet, that a person's culpability for murder has to be premised upon that person's own actions and subjective mens rea. So you shouldn't borrow or impute other people's actions or mental state to convict someone. And the law both updated the substantive law, these theories we just talked about, and also allowed resentencing for folks who had been convicted under a theory that we didn't recognize any longer, with some hiccups, as Rick will talk about in a little bit. Okay, so now we're after SB 1437. What happened to our four theories? Aiding and abetting express malice murder, that's fine, unchanged, still in place. Aiding and abetting first-degree felony murder, that's a killing that happens during a felony specified in the penal code. That is limited. You now have to have the intent to kill if you're an accomplice. So it looks a lot like an express malice murder, I think. Or you don't have the intent to kill, but you were a major participant in the underlying felony, and you acted with reckless indifference to human life. So it's not that you were just any accomplice to the underlying felony, but you had to these higher requirements had to be satisfied as well. So that's what happened to the first-degree felony murder. Second-degree felony murder, a killing during an inherently dangerous felony, was eliminated. Natural and probable consequences murder was also eliminated. So we got rid of two of the leading theories for accomplice liability and murders, really limited the other one, and then left express malice murder there. But then a fifth theory came on the scene after SB 1437 sort of became law, and that's aiding and abetting implied malice murder. And that's what Rick is now going to spend a little bit of time talking with you about to show the lay of the land. So Rick, you want to take over?
Yes, please.
All right. You're going to share your own slides, right?
Correct.
Okay. It's the same deck. It's just easier for them to press the button. So go for it.
All right. Okay, so as Tom mentioned, this is a theory that kind of lie dormant before SB 1437 was passed. And because it's one that applies to many of the same type of cases that the felony murder rule and the natural and probable consequences doctrine would have applied to. And those theories were easier to prove because the district attorney did not have to prove a person's mental state or malice. But once SB 1437 goes into effect in January of 2019, we quickly start to see a lot of cases in which this theory is being applied, starting with the California Supreme Court case in December of 2020, in which the court states in dicta that this theory is still viable even after SB 1437. Then there's a series of lower court cases that approve and apply the theory until, and then finally in June of 2023, the California Supreme Court directly addresses this theory in its decision in People v. Reyes. In Reyes, the court affirms the theory of aiding and abetting implied malice murder and comes up with the following standard for courts and juries to apply, which is a combination of the implied malice murder legal standard that Tom discussed. That's kind of a court interpretation of this archaic, abandoned, and malignant heart language, and the accomplice liability elements, which are kind of lengthy and confusing in their own right. And so the court says that in order for a person to be guilty of implied malice murder, the district attorney has to show that the perpetrator committed an act with a high probability of death. Again, this is not an express malice murder. This is a situation where the perpetrator committed an implied malice murder. The next element is that the accomplice knew the perpetrator intended to commit that dangerous act. The accomplice knew that the act was dangerous to human life. They intended to aid in that act. They did, in fact, aid in that act by words or conduct. And the accomplice themselves acted in conscious disregard for human life. Now, our next panelist, Jennifer Hansen, she's read all the cases that have applied the standard, and we'll talk more about the type of cases that this theory is being used in. But generally speaking, it's being applied in the same type of cases that SB 1437 sought to address. These are cases in which the accomplice is not the actual killer and did not have the intent to kill. And so a common example would be a group or gang fight where a group of people intentionally go to beat up or harm another person. The accomplice is a part of that group. Maybe they're throwing punches. And while that's happening, somebody in the group pulls out a gun or a knife and kills the victim. In that case, the accomplice, who didn't actually kill anyone and didn't intend to kill, and maybe didn't even know that the other person was armed, could be convicted of aiding and abetting an implied malice murder. And this seems to be the very type of case that SB 1437 sought to address. That law was going to bring more rationality to when an accomplice could be convicted of murders they didn't commit. And somehow this theory escaped that law. So the staff recommendation here is to align accomplice liability for implied malice murder with SB 1437. And we offer two different options to accomplish this. The first is to eliminate accomplice liability for implied malice murder altogether. And if we did this, the accomplice would still be guilty of all the other crimes that they committed or assisted with, which could be significant. We're talking about serious felonies in which a person was injured, killed. So these are significant prison sentences. But the other option would be to create a new offense. And we suggest third-degree murder, which would have a determinate sentence, unlike our current murder sentences that have either 15 to life, 25 years to life, those indeterminate sentences. The third-degree murder sentence would have a determinate sentence so that an accomplice who didn't kill is not given the same indeterminate sentence as the actual killer. Moving on, I want to have a very brief discussion of the resentencing limitations of 1437. As Tom mentioned, 1437 allows people who are convicted of murder under one of the now abolished theories to petition the courts for resentencing, saying that they couldn't be convicted of murder under current law. But these petitions can be denied if the murder conviction can be upheld by any other existing theory. And so courts, in determining these cases, are examining the facts and determining whether there's any other theory of law in which the murder conviction can be upheld. So judges deciding these petitions, they only have two options. They can either grant the petition and vacate the murder conviction, or they could deny the petition and leave the conviction and sentence in place. Courts have held that the language of the law does not allow judges to reduce the degree of murder. And so an example of how this plays out is that a person convicted of first-degree felony murder under the old law, which did not require the person to share the intent to kill or to be somebody who was a major participant in the underlying felony who acted with reckless indifference, they can petition for resentencing and have their first-degree felony murder conviction upheld, even if they couldn't be convicted under the current law, which requires them to be a major participant who acted with reckless indifference, as long as the court determines that they could be convicted of second-degree murder under a current theory, like aiding and abetting implied malice murder. In that case, the person's first-degree murder conviction would stand, even though they could not be convicted of first-degree murder under current law, only because they could be convicted of second-degree murder. And so, the staff recommendation for this section is pretty straightforward, is to allow resentencing courts in these circumstances to change the degree of murder. So with that, I'll stop sharing and I'll invite our next panelist, Jennifer Hansen, to talk more about the type of cases that she's seen this apply to, and of course, welcome any other questions the committee members have.
Thank you, Tom and Rick. That was super helpful. Jennifer, we'll give you 5 minutes and then we'll open it up for Q&A, which is usually our most helpful and productive part of our conversation. So take it away.
Okay, hi everyone. Thank you so much to the committee staff for covering that background. And thank you for inviting me to participate. I think I'm here because several years ago I participated and I worked on an amicus brief in the Reyes case that Rick was discussing when I worked at the Office of the State Public Defender. I was a co-drafter of the brief with a fabulously smart attorney, Sab Moiskovitz. He was the primary drafter, but I was involved, and I can say for the most part, as a criminal practitioner, we were pretty happy with the tightening of the definition of implied malice murder that came out of the Reyes case. We were very concerned going into that case that there could be the possibility that with a looser definition of implied malice murder and aiding and abetting, there might be the possibility that DAs would repackage the natural and probable consequences theory, which was abolished for use in murder with 1437. Like Rick said, with natural and probable consequences, DAs were able to get a murder conviction where somebody was merely participating in something like a disturbing the peace or an assault conviction. So we were very happy, to be honest, when Reyes came out and really highlighted the higher standard that somebody has to be involved in an act that's not merely dangerous, but actually life-threatening, life-endangering. So to prepare for this talk today, I shepherdized Reyes, and I was actually kind of shocked to see how frequently it's being cited. Honestly, it's been cited over 280 times, which is a lot for a new case that's only been out about 18 months. I narrowed down my search to do search terms for sufficiency to try to focus in on aiding and abetting implied malice cases. And I did find about 40 or 50, which was still a lot. And my impression, I have to say, was not all bad. I do think that courts are doing now a more rigorous review of implied malice murder. They're asking the question, what was the fatal act? Was this accomplice somewhere punching, or was he right there when the stabbing or the shooting happened? They're asking, was this behavior actually life endangering or just somehow nebulously generally dangerous? That said, having any kind of test which is going to encourage hair splitting in the context of multiple people doing violent acts is going to always leave some wiggle room for trial courts and courts of appeal to sort of editorialize and to do more results-oriented reviews. Obviously, it's not hard to say that something is life endangering when somebody actually died. So my materials highlighted a couple of cases that I think were, in my opinion, wrongly decided, even though they did apply the Reyes test. And so in those cases, I think, the courts didn't seem to care that nobody knew that the person was going to use the gun, or that nobody, the client didn't necessarily know that the person was armed. And they didn't seem to, they didn't want to focus specifically on the fatal act, being the shooting or the stabbing. They wanted to bring it back to the fact that people were doing another dangerous activity prior to the fatal act occurring. So overall, if this committee wants to leave the Reyes test in place and doesn't make any changes to the penal code, I can imagine that in the next couple of months or years, there may be other cases. There are going to be other cases that fall through the cracks, and maybe there'll be published cases that sort of water down this standard. I don't feel like we're there right now, but it could happen. One or two cases can really kind of change the court's application of these sort of more subjective factors. If the committee wants to talk about amending the law, my materials have highlighted some of the fact patterns that are pretty common in these cases. I think Rick and Tom both mentioned them. Group beatings, a lot of times gang overtones, where courts want to read in a lot of dangerousness and situations where maybe it's not clear who dealt the fatal blow, so you don't really know exactly whether the person aided and abetted the final act. I could see, though, some room to create some sort of a crime for people who do not intend to kill, do not know that somebody else is planning to kill, but yet we're involved in a dangerous activity and somebody died. At this time, that's not manslaughter. I think people have the perception that maybe manslaughter is a fallback, and that's really not manslaughter. So maybe a new crime could establish that option for judges and juries and maybe save some people from a life sentence of implied malice murder. So with that, I'll wait for further questions, and thank you for letting me participate.
All right, thank you, Jennifer. That was super useful and helpful. Before we get to Nathaniel, I wanted to discuss this a little bit as a group. I think it'd be most helpful, Rick, or Tom, if you brought up the slide with the recommendations.
Will do. Doing it now.
Okay, and then can you just briefly remind us the two recommendations? Eliminate murder liability under the theory of accomplice liability for implied malice murder.
Correct.
Okay.
So sort of take the most SB 1437 approach and say this is no longer an offense that we recognize. And instead you're left, as Rick said, with the other offenses that are usually committed in these fact patterns, or assaults, weapons are involved, often injury. Or we it's also pretty reasonable to recognize, well, what does happen in these cases is more culpable than just a normal assault, but the person shouldn't get a murder conviction, shouldn't get a life sentence as we understand it now. And so create a new offense that has uses the same legal elements and the same test as accomplice liability for implied malice murder, which, as we saw, are quite complicated, and call that third-degree murder or something similar. So you sort of acknowledge the seriousness of what happened, but also align the culpability with what happened as well, and not impose a life sentence.
Right, I understand number two pretty clearly. I think that's simpler, the creating a new offense of third-degree murder. I guess my question is, if we were to eliminate accomplice liability for this type of offense, would that create accomplice liability? Obviously applies beyond murder. And would it be kind of nonsense? Can you imagine? Is there a scenario, and I can't think of one, where it'd be kind of nonsensical? We hold somebody liable for accomplice liability in a robbery or burglary regularly. But if we eliminated it for this, would there be offenses where we'd be like, wait a second, but we hold people responsible for accomplice liability for robbery, but not for this type of thing? Would we be making some nonsensical?
I don't
I
think it's nonsensical just because
Right.
the whole premise of SB 1437 was that murder and the sentence for murder is the most serious that we have. We're dealing with an indeterminate life sentence. And for that reason, we need to have some more rationality and caution in who we give that sentence to. And so even SB 1437 left in place accomplice liability for all of these other offenses like robbery. And then I also think that there are other theories of accomplice liability that would remain for murder that would remain in place, like the first degree felony murder rule, for instance, in which a person, or the aiding and abetting express malice murder, where if the prosecutor can prove that the person intended to kill as well, then they can be held responsible for the murder. Or if they were a major participant who acted with reckless indifference, they would be able to be held responsible for murder. But in cases in which the person did not intend to kill and did not actually kill, then it would be saying that that person should not be held responsible for our most serious crime with our most serious sentence.
Okay.
And to your point about sort of the incongruity and accomplice liability for murder versus other offenses, that's the world we live in, where the natural and probable consequences rule applies everywhere else except outside of murder. So if one of the leading cases is an accomplice to a robbery who knew about the robbery could also be held liable for other offenses that the people did the robbery did during the course of the robbery under the natural and probable consequences rule. So there already is different rules for different offenses. So that's,
even though we eliminate, and you're saying we eliminated, so natural probable consequence for rape, you're liable for the rape, but because we eliminated it for murder, you can't.
Exactly.
I don't know who went first, but Professor Ochin and then Professor Rummel.
Thank you. I wonder about expanding homicide offenses when the person did not intend to kill, did not foresee or reasonably foresee that death would occur. I understand that there should be some accountability, but I am loath to support expanding the number of homicide offenses that are available. I'd wonder if we can think about other ways to identify and account for harmful behavior that ultimately does result in a homicide for which someone is being held accountable. But if the person didn't directly participate, didn't anticipate a homicide would occur, that someone would be killed and didn't intend for it, it seems to me the same rationale that we applied for, felony murder would apply in this context. So there's obviously they're accomplice to a crime. Perhaps that's aggravated assault with a deadly weapon. But it is not, in my view, homicide. And so that's just my comment. I would not be in support of expanding liability or creating a third category of homicide in this circumstance.
Right. So this wouldn't be expanding liability, it'd actually be contracting it, because these people can be convicted of second-degree murder right now. So we're saying that wouldn't be second-degree murder. It would be something less than that. And it maybe doesn't quite, and that's the question. Does existing law capture what happened sufficiently, or should there sort of be a new offense in between existing law and current murder law that captures this stuff? But our proposal is to take things that are currently punished very harshly, second-degree murder, and say they should be punished less harshly. So it definitely.
I get that. I guess
so it
my
wouldn't be
point
expanding.
is,
it wouldn't be expanding homicide law; it'd be contracting it.
No, I understand that point, but I guess if the option is bringing the current accomplice liability for implied malice in line with what was intended with the revision of felony murder, this should be eliminated as a theory of accomplice liability. And if we do that, right, if that's step one, step two, I do not think should be to create a new homicide offense of third degree murder. I think it would be to recognize a different theory of liability that accounts for the fact that the person did not intend to kill, did not participate in the killing, and did not reasonably anticipate that a killing would occur. So that's my concern. Is if I'm in favor of step one, which is eliminating this theory of accomplice liability, I am not in support of step two, which is to create a third offense, third degree homicide or third degree murder.
Yeah,
Professor Uchin, to your point, I would say one, that it's a little bit different from a person not reasonably anticipating it, because the aiding and abetting implied malice murder does require the accomplice to appreciate the risk of death and to act in conscious disregard for it. So there is some kind of subjective analysis of, did they reasonably kind of foresee this happening? But also, if we were to eliminate liability under this theory, it could, the fact that a death occurred during these underlying offenses that the person would be responsible for, such as assault and other offenses, that could also be used as an aggravating factor to increase a person's sentence. So that is one aspect that kind of, I guess, enhances a person's sentence based on their culpability without necessarily needing to create a new offense that we should consider.
Right. And I mean, and also, why not manslaughter rather than third degree murder? If it's, manslaughter is currently, recklessness or negligence. And it seems to me that is precisely the state of mind here. It would be that this person acted recklessly, that they did anticipate, or they did appreciate that there was a risk of death, and they proceeded anyway. And that seems to me to be more in line with manslaughter rather than creating a third category of murder. Right there, those categories exist for a reason. So why expand murder? And obviously, closing the loophole, it's narrowing it. I understand what you're saying, but rather than adding a third category of murder, why not amend and allow for judges and district attorneys to utilize manslaughter as a theory, which Ms. Hansen just said currently doesn't exist.
I see Professor Rummel's hand is up, but I just want to jump in real quick.
Yeah, please.
I think the part of the problem with manslaughter is that it requires provocation. And I think that's hard to prove in a lot of these situations where the people are going to go beat somebody up or going to do some other crime. That's just one thought on the manslaughter, but I hadn't thought about expanding manslaughter. So maybe that could be something that could be discussed.
I don't know, Tom, if you wanted to respond to Professor Urchin.
I think also part of the motivation for calling it murder in third degree is to sort of a pragmatic acknowledgement that if there is a dead body, oftentimes a jury is going to want to convict someone of murder. So if you give them a choice between sort of second degree murder or manslaughter, even if the facts don't quite fit second degree murder, they may be inclined to go in that direction. So it's it's not quite a legal issue.
But we would be eliminating that theory, right? I mean, assuming that we are successful in getting that legislation passed so that it's in alignment with SB 1457, that wouldn't be on the table, right?
No, I
So
think it still would. I think the argument would be, well, this is just implied malice murder and the person was more involved, or there was other theories that could sort of fill that gap.
I mean, granted that so many cases are resolved by plea, but they could leave it to the jury to decide whether or not they met the requisite mens rea requirement for second degree murder.
I guess I just don't understand why that wouldn't be the case, even if we created a third degree of murder, if there's still an option. So I'm confused here. So apologies if I'm not following.
No,
but
it's complicated, unfortunately.
It's super complicated. It would still exist. I think what Tom's point is that in that circumstance, and then we'll get to you, Professor Rummel, in a second. Sorry, I see your hand. In that circumstance, the jury would be charged with both second degree murder and third degree murder and have to choose between the two. versus being charged with second-degree murder and manslaughter and have to choose between the two.
Right.
I mean,
It's different
that-
theories.
I
I
mean,
think
I-
under the second degree murder theory, that in this hypothetical, the prosecutor is saying that this accomplice shared the intent to kill. They had express malice. And jury, if you don't find that they shared the intent to kill, then you can convict them of third degree murder, which has these requirements. So it's different requirements, but the prosecutor could present both and give the jury the alternative to prove it. So even though the aiding and abetting implied malice murder would be gone, the prosecution would still be offering up a theory under which the person is guilty of second degree murder, even though it's not aiding and abetting implied malice murder. That's a possibility.
And
Sure.
and the
I
defense
guess
counsel too.
Yeah, I guess I'm just not convinced that about the third degree murder being so substantially different that it would incentivize jurors to take the more serious offense as opposed to the manslaughter. You know, either way, you know, I'm supportive of narrowing and eliminating this theory of accomplice liability. I am aware that there are jurisdictions that do have accomplice liability for manslaughter. For involuntary manslaughter. That is a theory that other jurisdictions do use, and I'd be interested to know whether this theory that you have, that if juries are presented with implied malice, second degree murder versus involuntary manslaughter under a theory of accomplice liability, that they more likely take the second degree murder. I think that is something that we can test because there are jurisdictions that do have such such theories of accomplice liability.
I agree with
yeah, Professor Romo, go
Professor.
ahead.
Yeah, I want to say that I agree with Professor Ocean. She sort of made the point that I was planning to make, but now listening to this back and forth, it's helped me think about it a little more specifically. I think we need to go back to first principles, which is the reason we passed SB 1437 is so that people were not held responsible for something they didn't intend. I mean, it's the first class in criminal law. You know, what act did you do? We even have Latin terms for it. And what intent did you have? And murder is the only place in the law where you don't have to have an intent. And SB 1437 went part of the way to addressing that. And we've had some incremental additional ways that we've addressed it. And now we're talking about, you know, yet another way to kind of shut down people being convicted for crimes that they did not intend to happen. And we've got this sort of tangential theory about people who are usually young when they commit these crimes, having some sort of understanding of what is in someone else's heart, you know, their abandoned and malignant heart. And one of the problems is we still have theories of liability where someone doesn't have any intent because of the way implied malice murder is defined in California. I would be in favor of rethinking whether we need implied malice and maybe redefining it as just reckless indifference to human life, which was incorporated into 1437 and is a specific intent for the person you're convicting of the crime. If you demonstrate reckless indifference to human life, that is an intent that is recognized in the law and is a culpable intent, and then you can be convicted of a crime. But I feel like this suggestion just gets us more and more attenuated from, okay, well, now you can't be convicted of maybe knowing and understanding what was in someone else's heart when they didn't really intend to kill someone, but they were doing something really bad and you were with them. And I think, I don't know, I don't want to put words in Professor Ocean's mouth, but I think, you know, we're still not exactly where we need to be. That being said, I also understand the desire for someone who's involved in a crime that results in a death to be held differently accountable than someone who's involved in the same exact crime with the same exact intent that doesn't result in death. I understand that. I'm not sure how I feel about it, but I would make this suggestion, which is akin to what federal law does, or at least used to do. They have certain crimes where it's, you know, arson resulting in death. So you commit arson, you intend to commit arson, you believe the building is empty or whatever else it is, you don't intend to kill anyone, but a death results and you get an additional 5 years. So you're held responsible for the crime you committed and intended, assault, arson, carjacking, whatever it is. And there's no homicide involved because you didn't intend to hurt anyone and you didn't intend to kill anyone. Maybe you shouldn't have done what you did, and maybe it's reckless behavior, or it's something less than reckless behavior. And then there's I guess it's sort of an enhancement. It's resulting in death, but we take away murder culpability for people who didn't intend to hurt or kill anyone. I just don't think I think that's what SB 1437 set out to do. I think it was exactly what we should be doing. These are arcane common law England theories of liability that have been done away with in all the countries that created them. And I would be more in favor of not creating an additional murder offense, and not even continuing to couch this as murder liability. Just, we'd have to think about the language, but you're only responsible for what you intend. If you're involved in a very serious crime that results in death, not because you had any intent for that sort of an injury or act to occur, but because it does occur and because we're more angry about that as a society or whatever it is, you get an additional 5 years, but you're not guilty of murder. There's no liability for murder that should attach to that type of crime and result.
And I agree. Heidi said it much better than I did. Mine was much more convoluted. But I also think that, should juries choose second-degree murder in circumstances where it's inappropriate, we have to expect our appellate courts to do their work, and to ferret out those kinds of whether that's a reasonable expectation or not, right? That's what appellate courts are for. So I just would co-sign. I hate it when people do this in meetings, but I'm just going to co-sign what Heidi said.
I think that all your points are well taken, except for I'm dubious that courts would reverse that after jury finding. But Assemblymember Brian, I see you have your hand up. By Bagley-Keene rules, I think you have to be on camera unless you're having technical difficulties.
Unless we're screen sharing, actually, I rechecked. So if we're screen sharing, we're okay. And then I think he is having an unreliable internet connection. Sorry for all the preamble.
Got it.
Very unreliable. Right on the middle of nowhere. But just wanted to say to echo that I agree with the last two thoughts. I think it's a very, for all the technical reasons that have been mentioned, I understand how we could come to a conversation about a recommendation like this, which I think is appropriate, and I'm glad that we are at this point. But I do think if we take a step back and we look at the problem we're trying to solve and the purpose and function of this committee, it's just interesting, the idea of creating a new murder offense. Even for righteous and rooted reasons, I think there are maybe other ways we can address this, and the previous two comments kind of speak to that. So I would align myself with those comments.
All right. I think we're revolving around a consensus that at least suggestion number 2 of the third-degree murder is off the table. Senator Skinner, she just got up, but as the author of 1437, I was hoping to pick her brain on, is eliminating murder liability under this theory altogether most consistent with 1437, or does it go further? Professor Ochin and or Rummel, I hear loud and clear about the third-degree murder. I am Senator Skinner's back. Senator Skinner, I wanted to give you a chance to, as the author of 1437 and has thought about this so much more than certainly me, with the consensus that the third-degree murder suggestion is off the table, do you believe that eliminating liability for accomplice liability for implied malice murder would further it seems consistent to me with 1437, or does it go further than 1437? I was just wondering if you
I don't think it goes further.
Okay.
So I personally, I'm in the point of view that both Professor Ocean and Professor Rummel described. Now, that said, I'm also, having served in the legislature 14 years, kind of pragmatic. And I guess what I would like to see is some data on what my impression, and again, it's not a fair thing to say an impression without data, but my impression is that juries like, and this may be more as a result of prosecutors versus just the juries, but there is a tendency to want to convict for some level of murder if a death occurred during the crime. And as I am hearing, this new offense is to try to respond to that without having the type of consequence that our other sentences have. Now, at the same time, I'm also like, we shouldn't be convicting anybody of murder whose intent was not murder, or whose, we put these various we try to address this through things like without reckless indifference to human life, and et cetera. But anyway, the thing I'd want to see is what we would be correcting for from a data point of view if such a third offense were to be created. And that is without moving in the direction of recommending that we do so, but more trying to get some more background on it or data on it that would
in light of our
understand it better.
I think, sorry to interrupt, Mike.
Go ahead, Tom.
But I think the work that Jennifer did speaks to that a little bit, where we really are seeing courts try to apply this theory in a lot of cases, that it is coming up. It's not sort of a rare occurrence or rare bird, that it is sort of, filling that gap that we saw created by SB 1437. I think from some prosecutors' point of view, like, we still need to get murder convictions if there's a gang assault, basically, and the tools we had were taken away. And I think we're going to see, and perhaps it's going to get even more aggressive use of this theory, and that the facts are often so unsavory, for lack of a better word, that it is going to be very hard to expect the court system, I think, to reject convictions. I don't know if that directly addressed it, but I was shocked to see that there are already so many cases, basically a year after the California Supreme Court gave the thumbs up.
Yes, but is Jennifer still here? I can't see if she's here.
Yeah, she's here.
Jennifer, my understanding though from your presentation was, though, while it was the case was cited a fair amount, that you didn't see many opinions going in the direction of holding people responsible for murders that they did not foresee. Am I misunderstanding your?
Right, it was cited like over 200 times. It was really assessed more closely, like 50 cases. And I, found 5 to 7 that I think where they weren't applying this, they didn't actually require that the person knew that the perpetrator was going to do a life endangering act, or they didn't seem to care that there was no evidence that the person didn't know that the perpetrator was armed.
Okay.
But for me, that's a different
Right.
question. So that's like where the courts got the law wrong, and it's those other 40 cases where they said, nope, you can be convicted of this that we're seeing, but you can't. But those are by definition cases where the person didn't kill anyone or intend to kill anyone, but still engage in something helped in something so risky that death was a high probability. So I think we don't want to just think about the cases where the courts got it wrong, but where they are saying, yes, this was the proper thing to do. That is happening. I was surprised by how frequently it's already come up.
But may come up is one thing. How many? So what I hear you saying, Tom, is that with the elimination, with 1437 eliminating these prosecutors' ability to go and get felony murder, that prosecutors are trying to get a murder conviction under another construct. And so I guess what I'd like to see is, and maybe that's really what you were trying to give us, Jennifer, but is, have we had conviction? What's the level of convictions that resulted at or occurred as a result? Are we getting a higher number of convictions under some other murder theory, which we can't always completely correlate it to the elimination of felony murder, but that there's a high likelihood.
So yes, it does appear that it is happening. I think that that's the answer. Correct, Jennifer? Correct, Tom?
Yes.
Yes, I mean, and again, it didn't go into place until mid 2023. That's when Reyes came down, and then the jury instructions were just updated in March of 2024. So we don't have a lot of time, but it is an option that is, conceivably replacing natural and probable consequences sometimes. But it does have a higher standard. I mean, that's what I was trying to show, is that it does, I've done the appeals for 15 years, and basically anything would be the natural and probable consequence of anything historically. So it is a definitely more searching review. And but we'll have to see. I think there needs to be more study.
All right. So here's
Can I add something here? So I'm wondering, have we looked at the Model Penal Code's standard for accomplice liability? Because under their definition, basically where there is an offense that requires a result, like homicide, right? A person can be convicted as an accomplice if they have the requisite culpability, the state of mind for the underlying homicide offense. So that would be in the context of, for example, manslaughter, which is not currently, I don't think, a recognized theory, accomplice for manslaughter. Then you would need to be acting recklessly, right? That would have to be the question. And so for the jury, the question is, did you act with ordinary sort of criminal recklessness, or was it more aggravated, right? Where you had a reckless disregard for human life, right? So it's that, to me, sounds like the appropriate logical question. Is this an aggravated murder, which is second degree? Or is this a homicide that was committed with criminal recklessness, which is manslaughter, right? And that is a big difference in terms of sentencing. It's a big difference in terms of the sort of stigma and so on that's attached to that person. This is not just an academic conversation, right? Murder means something. And so we are acknowledging that the person that falls into this category, a person who, say, a kid who's 18 years old, who's participating in a fight, they're not guilty of murder. When they did not know that a person had a weapon, they didn't intend to kill, they intended to assault someone. They did not intend to kill. They did not kill the person. Someone that they were with killed the person. That is not murder. And I think we need to be clear about that. And of course, juries have to determine whether there are aggravating circumstances that would justify treating that kind of an event as equivalent to an intentional killing. That, to me, is, not that logical and rational and just rules the day in our legislature, but that, to me, seems like the appropriate way to resolve this question of holding someone accountable for helping to bring about a result that is horrific, but one that they didn't anticipate, one that, they might have even been negligent, in which case they might not be guilty of involuntary manslaughter at all. So, that's the question to me. That seems to be the appropriate alignment in terms of the question between implied malice murder, second degree, and involuntary manslaughter. The question is, was the person so reckless that they disregarded human life, that or not? And if they were not, then it's manslaughter.
Yeah, I'm persuaded. Tom and or Rick, why doesn't manslaughter do the trick here?
Rick or Jennifer probably know
That's
better
something
than me.
I'll kick that one to Jennifer.
I mean, I think it's not, you'll see it's not charged very often. I mean, if you go to court, the judge has to agree to give it a lot of times, sometimes over strenuous objection. I don't think that Like I said, there's issues
Objection
of
from, just to make sure, overstrenuous objection from the prosecution.
sometimes, yeah, or sometimes the defense doesn't want it because there might be a strategy. You know, I don't know. I think there's a lot of the closer question is involuntary manslaughter. And I think, like, you know, others have said, I think it's not common that is, you know, secondary murder versus involuntary manslaughter. It seems like a big jump. That juries are not necessarily going to choose that low of a crime, not even realizing that the penalty is very different. It's not often something that is a replacement. I mean, I think that the crime, like I talked about, some of the crimes that we're talking about are people that are stabbing while someone else is punching. I mean, I think it's gonna be very easy for courts to get to, you know, this is dangerous to human life. I mean, almost everything is going to be dangerous to human life. So it's got to be some kind of higher standard.
I really agree. And I really think what we're all kind of closing in on, and I know it's a little far afield from what's been recommended, but the accountability is that the crime they actually committed resulted in death. It's like an enhancement. It's not a new crime. They haven't committed a different crime. A crime requires intent. So if you didn't intend it, you didn't aid and abet it, if you didn't recklessly endanger human life, you haven't committed another crime. You've committed an assault or a carjacking or a robbery, and that crime resulted in death. And maybe we want to hold you more accountable for that, but it's not murder. It's not a life term. It's an addition. I would say it's additional 5 years, or, you know, something relatively modest, because you have not committed another crime. And as long as we continue to create crimes where there's no intent, actual intent, you know, needed to be proven, we're sort of pushing forward the same problem that 1437 tried to address in the first place.
Now, we at least have the enhancement for great bodily injury, right? That already exists, so that would already attach. And we're going to talk about the enhancements in a second too.
Right. But to the point of, like, a jury's going to need to, or judge is going to need to note that this is a death, or, you know, something like that with this.
Mm-hmm.
But yeah, it could look like that. It could look like great bodily injury, but it's a circumstance of the crime they committed. It's not a new crime. I don't know. I feel like that's an important point.
I hear what you're saying. I'm a little bit hung up on, I'll just speak out loud a couple of things. First is that we have this natural probable consequences for other crimes, right? And maybe that's like our problem altogether. You didn't intend somebody to be raped, but they were raped. We're holding them responsible for rape. So maybe that's something that we should look at, not today, next year. The other thing that I'm thinking about is what we want to recommend this year. And with this particular, our calendar and our ability to do additional research is quite limited. I think that we have consensus around that creating the third-degree murder offense, we're not going to recommend. I guess I would want to, we will vote later on our recommendations. Today is the day that we vote on our recommendations. And I guess I want to hear if people think that we should include as a recommendation number 1, which is eliminating murder liability for accomplice liability and implied malice murder in all circumstances. I think that there is consensus for that.
We could still revisit in next year a more global fix to this problem, or would this preclude us from addressing the issue again?
We can always do whatever. I'm just saying that, yes, we can go look back at this next year. We can gather more data. We can also punt the whole issue to next year. And take it off our table altogether. I'm just saying, in order to make our recommendations for this year, we have to decide today, more or less, what our recommendation is. And I think the question on the table is, do we punt the issue for further consideration next year with perhaps more data, model penal code, see what's going on in other states? Or do we recommend eliminating murder liability under the theory, number 1? We don't need to vote on this right now, but if anybody has any insight, it would be helpful, because we're going to vote on it later today after lunch.
Well, I'll just throw in there that on number 1, that was tried. That was an option that was presented. in some of the amicus briefs that were filed in the Reyes cases, look, there's no such thing theoretically as aiding and abetting an implied malice murder, and so we shouldn't even have this as an option. And the Supreme Court didn't agree. So I do
Right.
think it would fall to the legislature to do something if you want to take steps on that front.
Right. That
My
we're,
my
go ahead.
my question would be just to the legislators on the panel, Senator Skinner and Assemblymember Bryan, would proposing the elimination of the accomplice liability for implied malice murder on its own fare better or worse than if we had paired it with some suggestion to the legislature about how to hold folks accountable who are in this circumstance by expanding accomplice liability for involuntary manslaughter. When I teach criminal law, one of the things that I tell my students is that it's nonsensical to hold someone to be an accomplice for a reckless or negligent crime. It just doesn't make any sense. And there are obviously other theories that circumvent the lack of logic there. And so would it be helpful to accomplish our goals for eliminating this theory to provide another avenue for accountability for a lesser form of homicide instead of murder, which is currently what's being pursued in some circumstances?
So just so I understand what you're saying, Professor Ochin, and then I'll get to you, Assemblymember Bryan, I see your hand, to say eliminate accomplice liability for implied malice murder, but have clarity or understanding that it might be prosecuted under, for example, manslaughter.
Right, involuntary manslaughter, correct.
Yes,
And I guess the question is really if we have consensus regarding point one, right? We still may need to do some additional study with regard to accomplice liability for involuntary manslaughter, looking at the model penal code or other jurisdictions and so on. So if we propose only the elimination of the implied malice accomplice liability theory, does that not stand a good chance of passing on its own, or should it be buttressed with some suggestion about this is how we can also amend the penal code to have some accountability in the homicide category, or along the lines that Professor Rummel suggested, which is utilizing the death as an enhancement to aggravated assault or robbery or whatever crime was actually intended to be committed by the person who's being charged with the accomplice liability.
Understood. Assemblymember Bryan.
Yeah, I think the latter is more likely to pass in this current climate. I think just eliminating it outright, even if that's the right thing to do, or something that we would like to do and still study the outcomes of how it shifts prosecutorial movement or outcomes. I think currently in the current climate, unless you pair it with some other form of accountability, if we think that that's something that's needed or can anticipate on its own, I don't see it moving right now. We're in a very contentious moment. And that's something I think we'd have to weigh with any recommendations that we make to the legislature. If viability is one of our core considerations, some of the harder, more necessary, important work that this committee does, because we actually review the data, we actually bring in experts. In many instances, we are the source of data for many legislators. I mean, I love the work of this body, but if viability is one of the things that we're concerned with, it's really something that might hinder many of our recommendations.
Yeah, I always struggle with the question about viability. Sometimes I think that it should obviously be, we should be realists and we should recommend things that we think. On the other hand, I think that sometimes I feel like we should just recommend what we think is the best policy, period, and that's what our charge is. So I think that we struggle with that and should decide that as a group, but I think that's an important question. It seems to me that we should mull on this at least through lunch, and that the three options are: punt it to next year. No recommendation on this altogether. Recommendation 2, propose the elimination of accomplice liability for implied malice murder. Full stop. And option 3, which is eliminate accomplice liability for implied malice murder plus I suppose, an expansion of uh, um, manslaughter to make sure that we cover any bases that may be lost in the elimination. Those, I think, are the three options that we have to decide today. I don't think that we need to get much more specific than that with option number 3, at least for today. But I think that those are the three options. Does anybody see our options differently? Because we need to, yeah, Senator Skinner.
I don't necessarily see it differently, but I think, couldn't we adopt the elimination, where we had the most consensus, but in the discussion of it, rather than recommending that there be the sort of like an absolute, the expansion on the involuntary manslaughter, a discussion of approaches that could be considered versus a straightforward recommendation on it.
Yeah, I mean, I think it's certainly possible. All of our, whatever we say is just worth the paper that's written on anyway. So,
Well, yes, but I'm thinking, so I going back to both Assemblymember Bryan's comment and yours, I don't want us to be adopting things or approaching things purely on the basis of whether the legislature will act or not, because I think that we don't necessarily have that crystal ball, and right now I think both Assemblymember Bryan and I would say they won't do nothing. I don't mean, but
I'm more optimistic than both of you. I'm just telling
right,
you.
it's cool,
Go
but
ahead.
things can change. And we know they change. And we also know that a high profile case can occur, which completely incidents occur, timing is everything. So I think our job is to really articulate what we see as problems in the penal code and different approaches for revising that penal code to be more appropriate for our charge, which is public safety. So I think a discussion of it is good. And if I go back to 1437, nobody considered that possible or viable. And, it hardly got through, but look, it's had great results. So I think we should stick to our charge. However, well, whatever, I've said it. Yeah.
Yeah,
Just quickly, I agree with Senator Skinner. I think we
go ahead.
could make a recommendation, we generally believe people should only be held accountable for crimes they intend to commit. Here's one place in the penal code where that is not happening, and we suggest fixing it. But I think with a broader charge of here's what 1437 was about, here's what's important, here's what we believe is, the fundamental, basis of holding people criminally accountable for what they did and what they intended, something like that, and with a more specific recommendation just to eliminate the liability of aiding and abetting the.
Yeah, and I mean, and I think on that point, it also seems incongruous that the principal, if the principal had the same state of mind as the accomplice, they wouldn't be eligible for conviction under, for felony murder based on 1437. But the person who is the accomplice, right, can be held accountable. So I think this is sort of like cleanup legislation, clarifying legislation, because of this incongruous result. The person who is least culpable, as between the two, gets the heightened punishment.
Good. I think it's very important that that's articulated in the report.
I certainly agree with that. I think to Heidi's broader point, though, what I'm sort of thinking about are beyond homicide cases. Should you be held liable at all for things that you don't intend? That's a much bigger question, and certainly not for today. All right, I think we're sort of narrowing our thoughts about this recommendation. We will take a vote on it later today as to what we're going to recommend. It seems like we are coming to towards the consensus of eliminating murder liability as a theory, and then the question on the table is And do we actually recommend, or just in text discussion suggest that manslaughter may be some remedy if people are concerned that we're going too far? With that said,
Or a Heidi's
yeah.
suggestion, which is that the
enhancement.
death be used as an aggravating factor or enhancement.
Yeah. That would be a separate way of dealing with the same problem. Yeah, agreed. Okay.
Before,
With
Mike,
that said,
yeah,
yeah.
Go ahead. I think we're going to say
Okay,
the same thing.
Okay. Tom, I'm going to kick it over to you because we have two shorter issues to get through before our lunch break regarding accomplice liability. So, Tom, can you take it away?
Yes, before we leave SB 1437, and Rick, can you show the resentencing recommendation? Speaking of cleanup legislation, there is this sort of loophole in the resentencing procedures for SB 1437 where if your first-degree murder conviction is no longer good, but you could be convicted of second-degree murder, you get no relief. Your first-degree murder conviction stays in place. And we would just say, make it clear that courts could change the degree of murder, even though they're not going to totally vacate it. Seems like a pretty straightforward, commonsensical thing to do.
Okay.
I want to put a plug in for that because it is happening. It is happening that people have 25 to life, and the judge in 2024 says, well, I don't see you're guilty of felony murder, but you're still guilty of second-degree murder, so therefore I don't have to do anything and I can't vacate your conviction. So
I think that makes sense. I think that.
And to me, it furthers the goal of 1437, right? Because you're making people accountable for their own actions, and it just makes sense. You're not even actually releasing anybody. You're just getting them down to 15 to life, which would mean earlier parole eligibility. So hopefully it wouldn't be controversial.
Well, it would be controversial, but it's commonsensical and the right thing to do. Okay, seeing no other questions, let's do provocative act, Rick.
Right. Okay.
And,
so
and Nat,
provocative
who's been
act
very
murder.
patient.
Provocative act murder very quickly. A provocative act murder is when somebody's dangerous act, like initiating a gun battle, leads to a third party, meaning someone other than the perpetrator or accomplice, killing a person. Right. Courts have held that the felony murder rule can't be used in this situation because the person who did the killing is not one of the people who committed the felony. So the felony murder rule can't be used to establish liability. You have to use this other doctrine, which is the provocative act doctrine. And generally, if a provocative act murder is second-degree murder. But confusingly, once liability is established with the provocative act theory, the felony murder rule comes back into play. And if the underlying felony in which the provocative act murder occurred is one of the 14 enumerated felonies under the first-degree felony murder rule, now the provocative act murder that's generally second-degree murder can be elevated to first-degree murder. And then also the felony murder special circumstance, with the same 14 enumerated felonies that elevated the murder from second degree to first degree, can be applied as well to the case so that the person is eligible for a life without parole sentence or death. So this applies to a person who did not commit the actual killing and perhaps didn't intend to kill. And we're not saying that they, shouldn't be convicted of murder, but in this case, the felony murder rule that generally doesn't apply is being used to elevate it. And so the staff recommendation here is pretty straightforward. It's just to eliminate the use of the felony murder rule in provocative act murder cases so that you can't elevate it up to first degree murder, and you can't use it as a special circumstance to increase the punishment. So with that, I'll invite our next panelist to come and offer a few more words about that before we have the fuller committee discussion. I'll stop sharing for now.
Thanks, Rick. And hello, Mr. Miller.
Thanks, Rick, Michael. Thanks everyone for having me here. I really appreciate the opportunity to discuss this issue. I'm Nathaniel Miller, or Nat Miller. I'm a former staff attorney with the First District Appellate Project, now just Nathaniel Miller, attorney at law. My connection to this issue is that over the course of the past several years, I've been appointed to represent in a series of appeals a client who was convicted of special circumstance murder and sentenced to LWOP based on a provocative act murder. his murder liability was elevated from second degree to first degree pursuant to the felony murder rule. He was then sentenced to LWOP pursuant to the felony murder special circumstance. There are just a couple of things about this issue I'd like to emphasize. And the first is that California is really an outlier on this issue. In connection with my representation of this client, I've done extensive research into how other states approach this issue, how other states treat their felony murder rules in cases of provocative act murder or cases where the killing is committed by a third party. I've identified 31 states that have specifically addressed this issue, either through case law or through statute. And of those 31 states, 24 of them, the overwhelming majority, place significant limitations on their felony murder rules in cases like this. And they do this in a variety of ways. Some of them prohibit felony murder liability where the killing is committed by a third party. Some of them prohibit felony murder liability where the person killed is the defendant's accomplice. Some of them prohibit not just felony murder liability, but all murder liability in one or the other of those scenarios. And some of them limit felony murder liability to second degree. So that's 24 of these 31 states. There are just 7 states that don't place any limitations on the use of their felony murder rules in cases like this. That's California and 6 others. So California is in the clear minority on this issue. And this is an issue that there's an easy fix for it. Many states have already taken steps to address this particular use of the felony murder rule. The other thing I want to emphasize is just how limited the burden on the judiciary would be if this change were to be made and were to be made retroactive. I've done research through Lexis, through a legal database, trying to identify approximately how many people would be eligible for retroactive relief. I've identified about 30 particular cases of defendants who were sentenced to first-degree provocative act murder based on the felony murder rule. That obviously isn't going to capture all of the defendants, but we're talking a few dozen defendants, most likely, who would potentially be eligible for relief. And also the issue that would be key to determining eligibility for retroactive relief would be a pretty relatively straightforward one to determine. We're talking about either whether the killing was committed by a third party or whether the person killed was the defendant's accomplice, depending on exactly what sort of amendment was made. These are issues that are relatively easy to ascertain and not easily disputed. So I don't foresee retroactive relief giving rise to significant litigation or otherwise significantly burdening the judiciary. Those are the only 2 points I wanted to emphasize. Again, thank you for having me here, and I'd welcome any questions.
Thanks. I think we get it. Rick, I guess if there's anybody who wants to chime in, I think it might be helpful to have the recommendation on the screen. Okay, just eliminating the provocative act murder cases. And this is a situation where you go to a gunfight and the person who's killed is not the person you're shooting at, but a bystander. Is that right?
Or an
Well, yeah.
accomplice.
Or an accomplice.
And the defendant is not the person who killed them. That's
Right.
That's the other.
Another shooter killed the
and didn't intend to kill that person. May have intended to kill the initial target, but yeah, right.
All right.
A small
Anybody
impact, but very, serious impact on those people.
Do any members have questions?
Just a quick thought that this seems to make a lot of sense, but emphasizes that we're coming at all of this in kind of a piecemeal approach, which we've been doing since SB 1437 passed. And maybe it's time for the committee to look at a broader, even if we can't get it passed initially, a broader fix that deals with some of the fundamental principles that are wrong with murder liability in California, and then make specific recommendations under that same global fix.
I agree with that.
I think it goes beyond murder liability, but that's obviously not for today.
Well, I mean, to give a peek behind the curtain, which I'm sure you all are very interested in, when we started looking at this, we were thinking accomplice liability in general, but it blew our minds and we had to sort of try to break it down into bite-sized pieces. So we actually are going to propose that we return to it early next year again. But we wanted to, especially I think, focus on the SB 1437 issues while Senator Stanner was still with us for sure. And given that there was a Supreme Court case last year.
That makes sense.
And culpability generally is a very difficult question in these provocative act cases. I mean, some of the cases, as we discussed in the last topic, they're not all that sympathetic, in which an individual, one of the leading cases, an individual goes into a crowded club and starts shooting at a person, intending to kill them, and does shoot that person and hit them, but doesn't kill them. And then in response, the victim shoots and kills somebody else. And so it's not as cut and dry that we would say, well, that person has no murder liability whatsoever. That seems like a more difficult question. And maybe we fall, wherever we fall on that issue, but it seemed like the easier kind of piece to bite off, to Professor Romer's point right now, is to say, well, at least that person shouldn't be held responsible under the felony murder rule for a first-degree murder, and certainly not a special circumstance as well. It's kind of enough to extend liability for them for murder liability to a killing they didn't commit and allow them to be convicted of second-degree murder. And the bigger question is, well, should they be culpable at all? But that might be an even harder question.
I mean, we do have the reckless indifference to human life standard. Like we already have that in play with as an exception to the felony murder, to SB 1437. And I think it's a good substitute for abandoned and malignant heart. But that's a bigger, broader conversation. But if we continue to go piecemeal at these things, we're never going to correct the fundamental problem.
And to the extent that we're talking about accomplice liability, I think I mentioned this before, but I'm just going to put it on the table. I really would like for us to look at how accomplice liability affects women, and the number of women that we have in state prisons that are serving LWOP sentences based on accomplice liability, and the intersection with intimate partner violence. So I just want to really emphasize that I would like for us to have that conversation.
Yeah, and I just will that's a very good point, especially in light of the data that we heard earlier today that showed a large disproportionate number of women who were benefited from 1437, the retroactive relief resentencing rule.
It's in the works. That's all I'll say now.
Terrific. Senator Skinner, and then Mr. Miller briefly.
I want to reiterate Professor Ocean's because I feel like we it's appropriate for us to be approaching all of our recommendations and all the things we take on through the lens of the penal code, which of course is our charge. However, when I look at the who's in our women's facilities and what they're convicted of, it seems to be we can't fix it solely and only from, well, perhaps there can be adjustments to the penal code to allow for more accommodation for the either intimate partner violence or other factors. But if we just doing it from a straight penal code perspective, we may not get at this what appears to be pretty obvious, which is that we have a disproportionately large number compared to our incarcerated men, of women serving these long sentences. We obviously have too many people serving long sentences in California. It's a feature of our system. However, if we take it on a per incarcerated individual basis, it's disproportionate in terms of the number of women. And it's hard to imagine that we have that many more women proportionately than men who have, either committed murder or taken the kind of act that most of the public views associated with these types of long sentences. So I just wanted to reiterate Professor Ocean's comment.
Yeah, I think this is a super interesting issue, and I think that part of it is also, do women get sentenced to prison for lower offenses, which could skew the numbers why for that it's a disproportionate number of women serving homicide. There's a lot of data to unpack, and something that I think that we should send the CPL team into looking at. Mr. Miller.
I just wanted to clarify briefly that a person who commits or attempts to commit an intentional murder during which someone, say, fights back and kills someone else, that person would still be eligible for first-degree murder, first-degree provocative act murder, even if this proposal were enacted, because that person's murder liability is elevated from second to first degree, not pursuant to the felony murder rule, but pursuant to the premeditation and deliberation
of the initial attempted murder. Yeah.
Exactly.
Okay, so who does this? Can you give us a situation where this proposal would?
Yeah, well, my client and a friend attempt to commit a robbery.
Okay.
The intended robbery victim fights back.
Okay.
Shoots my client, shoots and kills my client's friend. My client is convicted of special circumstance murder. My client did not intend to kill the intended robbery victim. He merely intended to rob him. That's not just the scenario in my case. That's the most common scenario in which this rule would prevent a first-degree murder conviction.
And our previous conversation of eliminating the accomplice liability would not attach there. Is that correct?
I don't believe so. What would make a difference would be, I'm hearing some conversation about potentially tightening the definition of implied malice. That could potentially eliminate or at least narrow the provocative act doctrine. The provocative act doctrine is a particular application of implied malice murder, and I think sort of a poster child for how broad and amorphous the current definition of implied malice is. But I don't think eliminating accomplice liability for implied malice murder would impact provocative act murder cases.
The issue is implied malice. I mean, the bigger issue that touches on all the things we're talking about is how implied malice is defined in California.
Yep. Does anybody have any further thoughts or questions? We have one more topic to touch on briefly before lunch. Before we do, does anybody have anything more to say about provocative act murder? All right, Tom or Rick, do you want to talk about enhancements?
Yes, I'll take it up from here. So 2 firearm enhancements that we'll talk about. The first being the armed enhancement. This enhancement applies when a person has a firearm available for use during the commission of any felony. They don't actually have to use it. So think about a robbery where a person has a firearm in their waistband, but they don't ever pull it out. This enhancement adds 1 year to a sentence for any underlying felony crime. And it could apply to accomplices who aren't personally armed, who don't have the firearm in their own waistband. And interestingly, it doesn't require the accomplices to even know that the other person is armed in order for it to apply. Some data on this enhancement. There's about 2,000 people admitted to prison over the last 10 years with this enhancement. 87% of them are non-white. 50% were 25 years old or younger at the time of their admission to prison. I'm sorry about that. And
let me just jump in there right there. 2,000 people admitted with the gun enhancement or with the gun enhancement as an accomplice?
With the gun enhancement for this one, we're unable to determine whether the person is an accomplice or not.
Got it.
We can't see whatsoever. So, you know, a smaller amount of people for sure. The next one is the use enhancement in gang cases. And this enhancement is referred to as a 10, 20, or life enhancement because that's how much time it adds to for personally using or discharging a firearm during certain enumerated felonies. So these are listed felonies that are violent felonies. If you use a firearm or discharge it, you can get 10, 20, or 20 or life sentence added to your sentence. Generally, it does not apply to accomplices. You have to personally use the firearm in order for it to apply. However, there's an enhancement in gang cases. So if a person is charged with an underlying felony, they're also charged with a gang enhancement, saying that the felony was committed for the benefit of the gang, then you, an accomplice in that situation, can have the enhancement applied to them, even if they didn't personally use or discharge it. And in those cases, like the armed enhancement, there's no requirement that the prosecutor prove that person's mental state, that they knew about the firearm, that they intended to use it at all. And so these are cases that are already very serious because they're enumerated violent felonies. They're already more serious because they're getting the gang enhancement applied. And then now we're also going to apply this 10-20 and life personal use enhancement to accomplices who maybe didn't even know about it. The racial disparities in this one are more significant, but there are only about 603 people admitted to prison with both the gang and personal use enhancements, but over the last 10 years. But 96% of them are Black or Hispanic. This tracks with some of the data we looked at just for the gang enhancement generally. 50% were 25 years or old or younger at the time that they were admitted to prison, and are kind of, we don't know, with certainty the number of people who were convicted as accomplices versus actual perpetrators, but our kind of back of the envelope math suggests that about 18% or a little more than 100 people were not the actual gun users. They were convicted as an accomplice. They didn't actually use or discharge the firearm and are serving time for this enhancement. So the staff recommendation here for the armed enhancement is to require that the accomplice actually know that the other person is armed for that 1-year enhancement to apply. It would not require the defendant actually be personally armed for the enhancement to apply, but there would have to be some element, some proof that the person knew about the firearm for it to apply. For the use enhancement, the recommendation is to require that the accomplice actually intend to use the gun, that they share the intent of the actual perpetrator in using the gun for the enhancement to apply. It would not, again, require the person to actually use the gun, but they have to know about it. They have to share the intent to use it in order for it to apply. So those are the recommendations for the enhancements. Happy to answer any questions.
These make a lot of sense to me, under the same idea about being held responsible for things that you intend to do. The gang stuff is particularly troubling to me, and not only because of the racial dynamic, although largely because of that, but also because we're not just talking about 1-year enhancement. We're talking about really severe enhancements. Senator Skinner.
What would, not being a lawyer, I don't, if we were to change it and say, you have to know, what is the kind of proof? Because I would guess that any prosecutor is going to go, hey, if you are part of that gang and gangs, use guns, you knew. I mean, in other words, so I don't know if that's going to be adequate, depending on what it is that it seems to me. If we should just eliminate that you cannot have such an enhancement if you don't have it, if you weren't the accomplice thing that you were talking about, Rick.
Yeah, it would be circumstantial evidence. Your point that the person was in a member of a violent gang that is often armed and often uses weapons. That's certainly circumstantial evidence that they knew the person was going to use a gun. There's often, in these type of cases, there's today's day and age, there's often social media trail of establishing knowledge, probably prior events in which a person used a gun that can establish knowledge. I mean, it's a very case-specific, fact-specific analysis in which there's going to be circumstantial evidence. Obviously, there's a circumstantial evidence instruction that tells jurors that, if there's two different conclusions they can draw from circumstantial evidence, one pointing to guilt, one pointing to innocence, they're supposed to take the one that points to innocence, but it's up to the jurors to apply that. I think a full scale, law saying that accomplices are never liable for the use enhancement might be a little bit overbroad, because you can imagine a scenario where one person hands the other person a gun and that person fires it. In that case, should that accomplice who also intended to use the gun but didn't actually wasn't the one who actually fired the shot. They seem kind of more responsible than the person who didn't know about it at all. So, you know, there is some, I guess, some gradation in
Right, but
culpability there.
But right now we're talking enhancements. We're not talking we're not talking about what fundamentally you're charged with. And so there could already be some aspect going back again to the action and reckless of indifference towards human life. There's any other number of
Sure.
things that obviously the person might have been charged with. Seems to me that if you're going to have a firearm enhancement, you should have to have the firearm or use the firearm.
Right. Yeah. And to your point, that's the way this enhancement is written, you know, to require personal use, and that generally it doesn't apply to accomplices. And also to your point, you know, there's other offenses that the person is charged with. Particularly, this is a case where it's already a serious felony, is already a gang case. The person is already facing a very lengthy sentence. In the scenario we're talking about, they're facing that lengthy sentence based on accomplice liability, so something that they didn't necessarily you know, complete themselves. So to kind of add on and add on and add on, maybe the best solution is just to say you can't do it at all.
Professor Rommel?
I agree with Senator Skinner and Rick's last point. I mean, just the fact that we make such a huge exception only for people with gang enhancements in this day and age under California law, understanding all the implications of how we prosecute people involved in gangs and how the racial disparate impact of that. I think it's problematic. Again, you know, if we make a broad recommendation, people should be held accountable for what they do and what they intend to do. I don't think we should be making any exceptions just because someone was in a gang. There's no concern that people who commit crimes related to gang activity are going to be more than sufficiently punished in California. That we don't need to make any sort of exceptions. I would hold them to the same standard as everyone else who commits a crime with a gun.
Yeah, I agree. I guess though the question is though, Senator Skinner, are you suggesting, and perhaps Professor Rommel, are you suggesting that we limit the armed and use enhancements even further? Right now, the staff suggestion is just that the accomplice have knowledge or intent, but not be the actual
How do you
perpetrator.
prove the knowledge or intent? And it seems to me if it's gang associated, there's automatic assumption that okay, of course you knew.
So eliminate it altogether. I mean, the way that you'd have to prove it is that they would say you have to have proof beyond reasonable doubt that I knew that Tommy had a gun.
You know,
Wait, did I misunderstand the law? And I'm not as familiar with these enhancements, but didn't Rick say that for everyone non-gang in a non-gang related crime, you actually have to use the gun or carry the gun, or that's
Right,
not
yeah.
true for everyone else?
Well, correct, for under the use enhancement.
Right.
Right.
Under the armed enhancement, you do not have to use the gun
Or know about it.
or even know about it.
Oh, so we're just talking, I see.
These are two separate enhancements.
I see.
I think we have sort of been talking about both,
We have been
blurring the
weaving.
edges a little bit.
We've been doing the weave.
But you're actually right, Professor Rummel. For the more serious enhancement, the 1020 life enhancement, you have to personally use the gun, period, unless you're in a gang. And then we have these complicated rules. And yes, it would be much easier. It would add clarity to the penal code. You just say, no, everyone's treated the same, but the gang status doesn't matter. Just delete those sections, basically. And what we have here is sort of a middle ground saying, let's just remove the most outrageous part, in our opinion, which is you don't even have to know the other person has a gun, and you still don't have to personally use it. But we could very easily say, no special different treatment for gang cases.
I would be in favor of that. I mean, I understand that we're not the legislators, but we can make the recommendations, and they can be responsible for whatever compromises have to be, achieved in the process. But I think we still make the recommendation we believe is appropriate.
I forget, was on our original report when we went into the gang enhancements, did we recommend eliminating them altogether?
No, because it was it's a half and half, where it was originally done by the legislature, then modified by voter initiative. And so I think in our first year's report, we didn't want to recommend anything that required more than a majority vote. So it was sort of a weird weird law and a weird circumstance that year.
But the consensus was that in general, the gang enhancements were very problematic to say the least. All of
Yeah,
them.
Yes.
92% people of color. I mean, it's kind of the same issues we see here. Young people and people of color receive the harshest sentences based on these enhancements.
If I
And
remember
there is a
correctly, in
lot.
Los Angeles, go ahead.
There is a lot less use of them, and from what I've seen, the prison's admission data. Anyway,
Oh,
sorry, I didn't mean to interrupt, Mike.
That's good. That was Assembly person, now Congressperson Kamlager's bill. So shout out to her.
Mm-hmm. AB 333 still being heavily litigated in every court in the state. But yes, but I think, and similarly, there could be a broader proposal from the committee on the armed enhancements, which just adds 1 year, and actually is the only gun enhancement I think that doesn't make the offense of serious or violent one. So the data we're showing, I think, is an incomplete universe a little bit. But you could say, okay, you also have to personally have the gun in those cases as well. That would be a bit more of a, it would kind of be one recommendation where there has to be a personal use or arm of the gun for both enhancements. That would be a more straightforward recommendation, but there are some differences.
We'd essentially be eliminating accomplice liability for these two enhancements.
Yes.
All right.
I think technically an accomplice who, even if you did that, an accomplice who did not personally have the gun on their person could still be convicted of the armed enhancement if it's proven that they were armed, meaning they had it available for offenses or defensive use. So if another accomplice had it, but the other accomplice knew about it, had it available, they could still be convicted.
I guess the situation that people might suggest is where one more powerful gang member says to another gang member, "You here, take this gun and shoot that person."
Right.
Where the more power, in my example, the more powerful gang member is using the other person as an instrument to do.
But there are other parts of the law that would deal with that situation. Like if that's going to negate someone's intent, then there's other legal principles that deal with it. I guess my point was eliminate the accomplice liability that's not true accomplice liability, where the person knew and intended for the use of the gun in exactly the way the person intended it. It's to have some sort of lesser. I mean, I think accomplice liability is not the issue when someone knows and intends for the act to be carried out exactly as it's carried out. It's that we chip away at those requirements, which are like basic criminal law for gangs, and which is mostly people of color, and murder and other sorts of ways. So I'm not opposed to strict accomplice liability, like as it's always been originally construed, but to be making it less onerous, or to make exceptions to it, or to chip away at the intent requirement for certain categories of people, I think is hugely problematic.
All right. So I'm sorry, Professor Rommel, where would you suggest that our proposal land?
Sorry, I need lunch.
Yeah, we are.
I need to look at the different laws. Sorry, I need to look at it all before I.
Okay. No pressure, but we do need to make a recommendation to this afternoon. So, on the table at least is for I'm just going to reiterate basically what's on the screen so we know that at least the starting point, and the question is, do we want to recommend something further? But as a starting point, the proposal is for the armed enhancement, require that the defendant knew that their accomplice was armed. Right now, you do not need to know that your accomplice is armed. That seems to be a pretty modest and common sense and fair solution. The second is within the use enhancement, which is less commonly used, but is used in the gang context and has much, much stiffer penalty, would require that the defendant intend that the gun be used, even if they are not the actual person who's using the gun. Those are the two proposals from staff as they stand. The question is, do we want to amend those one way or another further? We do not need to make that decision now, but we need to make that decision by the end of today. Professor Rummel or anybody else does want to chime in before we take a lunch break? And
I feel that it should not be as simple as know about the gun, because it seems to me too way too subjective.
all right, just so we know, you don't even it's not subjective now. You do not
I
even
know,
need to.
I know, but
Oh,
I
okay.
feel, in other words, I want to recommend something stronger, more expansive, more
Go for it. Go.
likely to result in the enhancement not being used inappropriately. So I don't have a suggestion for the language, but that's what I would recommend to staff. And certainly, yes, we
Well,
have to make some we have to act today. However, our final language is something that we review later. So we can
absolutely
correction to staff. And then on the last one, again, I would tighten it, that they would something about, a more actively on the sharing of the intent.
Sure. So that's absolutely correct. A cleaner way also to do it is you could say that for the armed enhancement, for the first one, say that you have to personally have the weapon available for offensive, defensive use. You have to know about it, obviously, and you have to have it available. And for the other is to personally use the gun.
Yeah.
Remove the gang exception.
Right. I think for that use enhancement, it's actually different from most of our other laws in our penal code, our accomplice liability laws that allow you to be responsible for something. That particular enhancement says only the people who do it are responsible. But it gives us this exception in the gang cases that says, okay, we'll do our regular accomplice liability laws for gang cases. So tightening that would be kind of going back to only the person who did it can get it.
And it is an enhancement. It's not the crime. People are still going to be convicted of aiding and abetting the robbery, the armed robbery, the murder.
Right.
We're talking about the enhancement specific to the specific conduct related to the crime. So I'm not even sure accomplice liability should flow to enhancements, but I'm going to have something to eat and think about all this.
And
I think you've identified the point, Rick.
And this
Can I just ask? Can I ask a silly? Can I ask a silly question? Why don't we just have the same intent for use and armed, right? I mean, the use statute is only for gang cases. The armed is broader, right? So if we believe that the person ought to know and share the intent of the person who used the gun or should possess it entirely, why aren't the standards the same? I mean, it would obviate the need for the gang enhancement because it would bring everybody to the same standard. But I guess I'm just wondering why not recommend that they both share the same standard.
It is confusing that we have different standards and different enhancements for use of a firearm and being armed with a firearm.
It sort of makes sense to me because being armed, you don't really need to have done anything. As Rick said, it sort of needs to be available. So if you sort of have a gun in the center console in your car, you don't have to have it in your waistband or anything like that. So it's kind of a.
Well, the waistband are you using a firearm if you have the gun in the waistband, but you never bring it out, you never brandish it, you never do anything?
As long as it's available for offensive or defensive use.
No, that's
armed.
That's
being I'm sorry. All right, I need lunch.
I guess in that case, my recommendation would we would use the language that we have for use for armed, and then for use it should be that you actually use the gun.
Right, personal use, right.
Personal use, right. The question we're talking about is in the context of accomplice liability. So we're saying to eliminate the right now. There's right now you have to personally use a gun, except if you're in a gang. And we're saying take away that gang enhancement, the gang exception altogether, for all the reasons that gang, well, for two reasons, for all the reasons that gang enhancements are problematic that we've addressed before, and for the reasons that accomplice liability is problematic in addition. So it really attaches to two of the problems that we're trying to address today. All right. With all that said, I think it's time for lunch.
Yeah, we've basically done the whole criminal law course in about 2.5 hours, so it makes sense that we're a little whatever punchy.
Well, first of all, thank you especially to Tom and Rick and Jennifer and Nat. This is really complicated, dense stuff, and this is, I think, really what we're meant for. We're trying to dig into weeds in ways that legislatures don't always have the time or the patience to do. So that's what we're here for. So thank you. I think it's core to our mission. We're going to take lunch break, and then we're going to come back. And at the end of after lunch, we have basically broadly two things that we're going to discuss. First, we're going to hear some updates about the Racial Justice Act and how it's being implemented or not. Not so much that we're going to make recommendations about the Racial Justice Act today, but really because there's been some questions about it in the committee, and so we can begin to mull it over, because I do think that it's something that we should wade into probably next year. And then the second big piece of business after lunch is to go through the recommendations that we've been talking about all year, and we will vote on those recommendations, which then staff will write up. I think that Senator Skinner's point is well taken, that for some of the recommendations, we might say yes, with details to be ironed out between now and our final meeting with staff and a particular member of our committee, if that needs to be done. All right. Thank you all. Let's reconvene at 1:15. Is that enough time for everybody? Any objection? All right. 1:15, please everybody have a good lunch, cup of coffee, and I'll see you at 1:15. We'll reconvene then. Thank you so much.